Well, joining me right on the top of this show is, of course, Mr. N.Ram, the senior journalist who wrote those articles which are now subject of that court case. Mr. Ram, good evening and thank you for joining us. I know that there was some joking across the country of the fact that the government said that these top secret, extremely classified, sensitive to national security documents were in fact had been stolen from the Ministry of Defense. Was this just a way to get this appeal dismissed?
I think that's one interpretation I've heard from some journalists, legal correspondents, as well as lawyers, that it was really about the review petition, and they were very keen, the government, that it should not be entertained by the Supreme Court, and whether this was incidental. But we'll wait and see. I wasn't there, so I wouldn't like to comment on everything that happened. But one thing I can say is we did not steal the documents. We did not pay for these documents. These documents came because they were necessary. That information had to be out because it is relevant. It is legitimate information. You need to put it in the public realm. It should have been revealed to the public, made public. It should have certainly been revealed to Parliament and to an empowered committee of Parliament. It should have been disclosed to the Supreme Court in the submissions made by the government. And because this information was suppressed, and because there was a cover-up, if you like, on issues like the price per fully fitted combat-ready Rafale fighter jet, they wouldn't reveal that despite repeated demands by parliamentarians, by opposition parties in and out of Parliament, or issues like parallel negotiations, which came to light only because of our investigative journalism. Others also have contributed. I would mention here the Caravan, Wire, Scroll, and so on, as well as certain other newspapers early on. But we did the primary job, the main job, as we did in Bofors. Yes. I think we're lucky. So I say, yes. What I would say is we are fully justified in publishing this information because it is in the public interest. It is relevant. It is not something to titillate the public. It's not to seek.
Yes, Mr. Ram, let's discuss the specifics. Yes. And there's something very dangerous here for all journalists, for the industry in general. If the government is arguing before the Supreme Court, and the government actually believes that the publication of classified documents, like the ones that you have put out right now, amount to contempt of court, and also will bring in the Official Secrets Act. Now, by bringing in or invoking the Official Secrets Act, the government can force you or compel you to disclose your source, because if you don't, then you will then be in either contempt of court or you will risk perjury. Now, for the entire journalistic community, that is a very dangerous precedent, isn't it?
Yes, but we should not panic, on hearing this and so on. We don't quite know whether it was said incidental to the arguments opposing the review, hearing the review petition and so on, or represents government policy. But assuming it represents government policy, it is very dangerous because now I don't think I was told by our reliable journalists who were there that the Attorney General for India did not say that this was contempt of court. He said that it was published, perhaps he said that it was meant to influence judges and so on, which is not taken seriously from what I heard. But so far as the Official Secrets Act, he certainly said that, yes, that we are thinking of prosecuting the publications, the Hindu and so on. The Official Secrets Act is an obnoxious piece of legislation left over from the British Raj. It was meant to be a repressive act to protect the interests of the Raj against the people of India and the freedom struggle. Unfortunately, although it was debated in the Constituent Assembly, it's on the statute books, despite long-standing demands from anyone concerned with fundamental rights, free speech, and so on, that it should go. It should get rid of the Official Secrets Act of 1923. Yes. And but it's still there. It's rarely invoked against publications, news publications, and I think the public interest is a perfectly good defense against anything that could be. Secondly, the Right to Information Act also protects us, specifically Section 8.1 81I and 82 that overrides the Official Secrets Act. That is my understanding, and I've been legally advised on that.
Mr. Ram, the government first argued, based on your article, that you hadn't put out the entire document and it was just a half-truth. They then went on now to argue that these are stolen documents that shouldn't hold water in court. But no one has argued against the veracity of those documents. Nobody said these documents are false or forgeries. The government has effectively accepted that the documents published by you and your organization are in fact the truth.
Yeah, they never contested it. But I read this in the social media. A number of tweets said that now they've authenticated the document. That's a major gain, etc. Not that I had any doubts. Now, Faye, remember that when the WikiLeaks material was leaked by WikiLeaks and numerous newspapers, the New York Times, the Guardian, various others published, German newspapers published it. The Hindu also published the US embassy cables relating to India and Pakistan. Then also the US State Department said this was purloined or stolen goods. And we are not going to confirm or deny the comment on it, neither confirming nor denying the authenticity of these documents. But they did say stolen goods. The same thing said was about the Pentagon Papers when that was published, the New York Times and the Washington Post. And then you talked about Watergate and so on. So this is an old, tired old argument that this material should, anything leaked because you saw. Now you and I come into play as investigative or journalists only when there is suppression of information, when information is withheld or is not easily available, or there's a cover-up. Only then does investigative journalism get activated at all. So they are really questioning the whole discipline, the whole pursuit, the professional pursuit of investigative journalism. And I don't take that argument very seriously.
Do you also believe at this point the government argued or the AG argued in court that these jet procurements are meant for national security? See the recent events in terms of national security. An adverse judgment at this point would be detrimental to national security. Do you argue with that? Do you agree with that argument at all, Mr. Ram?
It's an irrelevant argument because it's a done deal. And secondly, nobody is questioning the quality of the Rafale jets, nor do we question the quality of the Eurofighter Typhoon, just as we never question the quality of the Bofors howitzer, or indeed its rival, the French Sofma howitzer, which in every trial came first, but Bofors won in the end, before the formal defense procurement procedure was put in place. Here, what we have shown is, apart from price, the failure to get good enough terms, as was promised in the joint Indo-French statement of April 10, 2015, a solemn promise made to the nation by Prime Minister Modi, joined by the French Prime Minister or French President in that case. So we question that. We also question the parallel negotiations. We expose the waiving of the anti-corruption clauses, the failure to even secure an escrow account, payments through an arrangement where the advance payments will be made to an escrow account, and so on. Bank guarantees were also done away with. Dissent was suppressed. There was parallel negotiations which undercut or undermined seriously, according to a Defense Ministry note endorsed by the then Defense Secretary G. Mohan Kumar.
Yes.
So on. So all this was necessary information that you and I are entitled to. Everybody is entitled to. Certainly Parliament should have been, this information should have been shared with Parliament, and certainly the Supreme Court should have been informed about it when it was looking into the matter. So,
Mr. Ram, do you believe that the things that you have exposed...
done a service to not just the public, but the Supreme Court itself, I think.
Do you believe that the things that you have exposed effectively in some reasonable doubt point to corruption? Or could it just be, for argument's sake, and for those people who are arguing it, could it just be that the Prime Minister was cutting short the negotiation time and making sure that India gets the jets India needs as quickly as possible? Because we do know that during the tenure of A.K. Antony as Defence Minister, almost no deal went through at all, and our defences and our forces were starved for equipment. Can it be argued through what you have just put forward that there was corruption, or was there just a hurry?
pay, corruption is not just bribes or kickbacks, commissions disguised, bribes disguised as, or kickbacks disguised as commissions. Corruption is also something that takes place, or at least criminal misconduct, when decision making, when the standard procedures are violated and what is laid down legally is, or by policy is violated, causing huge damage to the national exchequer. If you pay too much for the design and development of what are called India-specific enhancements, pay 1.4 billion euros, it is bargained down to 1.3 billion in this particular case, and that is spread over only 36 instead of 126 aircraft. That's a non-recurring or fixed cost. Then you are being taken for a ride, or at least that could be an argument made against the deal. If you're saying that I'll get better terms, the terms actually happen to be worse, because in the first case, bank guarantees were factored in. They were loaded in the costing. In the new deal, bank guarantees are done away with. So you're comparing non-comparables, but you claim that this is a better deal. If that is questioned, then I think how is national security involved? You're only strengthening the arrangements that secure India from such blunders or worse. And then there are there's also the allegation.
Here's the question. Do you believe that this is a fit case for the Supreme Court to relook at its earlier judgment that was based on a CAG report that then turned out to might have had some inaccuracies in it, as has been pointed out now? Do you believe the Supreme Court right now might see this as a fit case to overhaul its own judgment?
I'm not sure of that, because I read various arguments. For example, Mr. P. Chidambaram has gone on record to say this is not a matter to be taken to the Supreme Court. There are others who disagree with that. So I wouldn't presume to comment on this, because the Supreme Court saw its role in a rather limited way in its very judgment. Of course, the Supreme Court was misinformed by the government. There's no question about it. The government itself has said that there were factual inaccuracies that figure in the judgment. So I think that will be corrected, no doubt. I hope that it will be corrected, whatever comes out. But I'm not sure that the Supreme Court is going to, this story is going to go very far in the Supreme Court. But we don't know. We don't want to second guess the outcome in the Supreme Court. I watch it with great interest.
We all will. Mr. Ram, I know we agreed on a one-on-one conversation, but we have a very learned panel lined up to discuss this very topic. So I invite you at your own comfort to decide whether you'd like to stay with us. Let me introduce the rest of the panel right now.
No, I'd rather, because I've taken a policy decision that when I do a story, a good journalist like you, I'm willing to answer any questions. You can put me through the grill, but I don't want to be in a general discussion where bits and pieces are said all over the place. With due respect to the panelists, I don't even know who they are. I'm sure you have good panelists here, but I've taken a decision on it because it becomes counterproductive. You get a bit of say, and then somebody else barges in, or you barge in at their expense, and it doesn't make for a good debate. That's the reason.
Mr. Ram, then before I let you go, let me just ask you one last question, and this is actually the first question again. The government said the documents were stolen, and because those documents were stolen, they should not be examined or submitted to the court or the Supreme Court, and the Supreme Court should not consider them in its proceedings. Do you in any way agree with that? Do you believe the Supreme Court should consider these stolen documents as the government has portrayed them?
From all the reports we have, the Supreme Court itself said that if somebody is innocent and is using a so-called stolen document, then do you say that we can't look at it? Somebody who's going to be convicted. So I think that's the answer to the question. So I think undoubtedly these documents are fit to be seen by the Supreme Court, and now that they've been authenticated by the statement of the government itself in the Supreme Court, I think that question is, has been settled.
Yes.
If the document is relevant, they will certainly look at it.
Mr. Ram, also, just to go back to the previous story that you had done, where the government turned around and said that you have not fully published the entire page that you accessed, that the Hindu published half a page and a half-truth, where Mr. Manohar Parrikar had written a note at the bottom of that page that said, we're okay with this, in paragraph 5, we can sort it out, we're comfortable with it. And they accused you of only publishing half that page and only publishing half the picture. What is your response to that?
Yeah, I can now reveal that the the document we got only had what we published, because if you compare the two documents, what was leaked to ANI, that was also incidentally, they were also mentioned in the Supreme Court today. I learned it was also leaked to them. By whom? We have to see. Presumably by the Defense Ministry itself. Now, we don't have that document. I saw it only in the UNI when the UNI put it out. And if you compare it closely in minute details and minute and subtle details, they're quite different. Because the Manohar Parrikar, defense minister, then defense minister Manohar Parrikar's noting, non-committal noting, I must add, was made later. And if you just look at, just do a comparison, there are numbers there, 11, 12, 13. That's not in the note we have. So so it must have taken place later. And there's a 45-day gap between the date on which the note originates by Mr. Sharma and the noting by the then defense minister. That's the answer to it. We published what we got.
Yes. Mr. Ram, many thanks for giving us your time this evening. I appreciate that you've answered all of the questions we asked you, and we look forward to